Let's move to our team now. Jonathan Turley, you are first up to react to this now, sir. How do you hear it?
Well, I've just been reading the opinion. It's obviously sweeping. There aren't any real dissents, so it does look like it is unanimous, at least on the result. What they have a disagreement on is whether the court had to go as far as it did. Now, the most practical result of this is that the voters will be able to vote for the candidate that they prefer. This was a critical moment for this court in history. After all of the years we have spent in this republic, we came to a point where these states claimed that they could unilaterally bar the leading presidential candidate from ballots to prevent people from voting for Donald Trump. The court here spoke with a strong, and it appears unanimous voice, at least on the result, that that's not going to happen, that voters will vote. They'll make their own verdict, regardless of what happens in cases involving President Trump. They will cast the most important verdict of all. They will vote for the next president of the United States.
Okay, stand by there, sir. Let's get another opinion in here. Andy McCarthy, what's your read?
I think Jonathan is right about the bottom line sweeping 9-0 decision with respect to the states. But I think that this case is actually a 5-4 case on what may be the most important decision. If I'm reading this right, what they're saying is that Section 3 cannot be enforced unless Congress legislates through Section 5 of the 14th Amendment, which it has done in enacting a criminal statute, which would allow someone to be convicted of insurrection. What I gleaned from this is that they're saying that in the next January 6th, the next time that Congress is called on to ratify an election result, that Congress cannot use Section 3 of the 14th Amendment to try to deny Donald Trump the presidency if he wins the presidential election, which is pretty momentous. And it looks to me like Justice Barrett and the three progressives on the court are unhappy that the court reached out and decided that.
Shannon Bream, now that you've had a chance maybe to take another look here, anything about the Sotomayor, Kagan, Jackson contingent?
Yeah, I think Andy's exactly right there, and what Professor Turley said as well. There's not a dissent. They concur in the judgment, but they say they don't think the court should have gone to all these additional questions that they did. They said it was enough, and Justice Barrett said in her concurrence too, just to get to the bottom line that states cannot do this. It's not in their purview to do it. But the dissent, again, not dissenters, the concurrence that comes from Justices Sotomayor, Kagan, and Jackson takes a different path. They think the court goes too far. They say this: by resolving all these extra questions, the majority attempts to insulate all alleged insurrectionists from future challenges to their holding federal office. So they feel like the court went too far. You try to go as narrowly as possible. Again, they agree with the overall decision, but think that the court is trying to give too much cover to future candidates who may face this scenario, and they just don't think the court should have gone those extra steps.
Okay, Shannon, I'm going to show our viewers this map here, guys, if we could. I hope I've got the numbers right. Correct me if I'm missing a few. It appears that at least 9 states, all right, this applies to Colorado, but Illinois has a similar charge, so does the state of Maine. Maine is in Super Tuesday tomorrow. And then everything you see in yellow has a case that's pending. Does this nullify all of those, or some of those, or none of those?
Well, if you're asking me, I think we'd all probably agree that these states have lost their ability to do this, but I'll let my fellow panelists.
Okay, all right, Professor Turley, is it all these cases done?
I think they're all dead as Dillinger. I mean, when you read this opinion, there is no dissent that the states cannot enforce the 14th Amendment provision. The only disagreement, as we've been discussing, is whether the court should have gone even further to sort of close off future arguments or challenges without an action from Congress. The majority is saying that, look, you need Congress to act here before you can enforce this provision. Some of the justices felt they really didn't have to deal with that question. They didn't say, by the way, that they disagree with the conclusion necessarily, as much as that is a bit of a reach beyond where they need to go. And the dissent is saying, look, we have a long tradition of minimizing our footprint, of trying to stay confined to the question at hand. That's not much of a disagreement. You know, you keep in mind that for months now, this has been literally called an unassailable theory. Various professors and columnists have been saying that the only thing that will stop the disqualification of Donald Trump are the conservative justices acting as political robots. Well, this is a unanimous court rejecting that unassailable theory.
What's interesting, Andy, is this is obviously, no doubt, a big win for President Trump. A big win at the highest court in the land. It also makes the Biden team have to live in reality, that these court cases are not going to be the thing that gets Trump off the ballots or out of the race, that they are going to have to run against him. And what I'm wondering is, and I know you can't tell the future, crystal ball, but there are other cases that President Trump has asked the Supreme Court to look at. Would this ruling, with this kind of result and unanimity, at least on the fact that the states can't do this unilaterally unless Congress acts in those other provisions, which they're not going to do, does that mean that President Trump might have a better position going into the court on those other cases as well?
I don't think so, Dana. I think, first of all, it seems to me that in terms of minimizing its footprint, as Jonathan referred to, what this court wants to make clear is it is not deciding the 2024 election. This decision has been crafted in a way that, depending on what happens in the election, the court is essentially saying, don't come back to us after the election and have Democrats in Congress trying to disqualify Trump under Section 3 of the 14th Amendment. That's done. We're not doing that. However, they're gearing up for a September trial of Trump in the January 6th case. You can see that already from the reporting last week, where the Jack Smith prosecution team basically trashed what's previously been known as the unwritten 60-day rule, where the Justice Department supposedly won't take action that might influence an election. They said last week that's not operative. The New York Times, in its reporting about this particular case that came down today, noted that if the court kept the same pace with respect to the immunity case as they've kept with this Section 3 case, that would open up the door to have a September trial of the January 6th case in Washington. So I think the Democrats are very much banking on court action to hurt Trump's campaign, maybe fatally. And I think the Supreme Court is saying, we don't want to be involved in this come after Election Day when somebody comes to us and asks us to disqualify him.
That's really interesting, because you and Turley and Shannon, you've been telling us for a month that this decision would be, even on the day it was argued, you said it's 8-1-9-0. And all three of you were right on that. Amy Coney Barrett says, I think it's her last line, all 9 justices agree on the outcome of this case. That is the message Americans should take home. And so this was argued on the 8th of February. It was rendered today, right? March 4th? That's 25 days. I mean, Shannon, you'd admit that that's lightning fast for the U.S. Supreme Court. And so now we've got this immunity case the third week of April. And you've all been telling us that it's quite possible they could issue a decision on that by the end of June. What I think is really interesting about the timing there, if you look at the calendar, for the past couple of years, and we've been doing the show for a while, so we know it's really not the last week of June, right, Shannon? The last couple of years, they bleed into the first week of July. And this year, Monday is July 1st, Tuesday is July 2nd, Wednesday is July 3rd. Then America goes off on its big holiday weekend. And I think based on today's decision that we're going to hear from this court on immunity right before America goes into the July 4th weekend. That may decide the outcome come November.